Thank you, Deputy Speaker. And I rise to share my concerns also with regards to the Migration Amendment prohibiting items in Immigration Detention Facilities Bill 2017, because this bill, of course, purports to make detention centres safer. And while Labor will always consider reasonable and proportionate proposals to improve safety and security in these centres, the government has fundamentally failed to make the case for this legislation. It compromises human rights, it creates harsh new search and seizure measures, and it gives the minister unchecked power. It also continues this government's very concerning pattern of harsh punitive policies against asylum seekers. Since coming to power, those opposite have taken every opportunity to eliminate any remaining vestiges of compassion from this very sensitive policy area. And I think it is a grave error to mistake compassion with some kind of sense that this is going soft on border control, which is the kind of rhetoric we've grown very used to be honest. And I've got no doubt that the minister and some members opposite might well try to distort, contributions from this side of the House as some sign of, if you dare express compassion in a debate, that there's somehow, a sign of weakness. Well, it's a very, very narrow-mindedly focused person that that asserts cruelty is somehow tantamount to being kind at the long run, and compassion is somehow tantamount to being soft on security issues. I think that's a very limited and unhelpful debate that occurs very often in this House and indeed outside. Certainly there are many examples, I guess, as to why Labor would be concerned about allowing unchecked powers to the minister, and I'll come to that again sometimes later in the debate. But really, the government's record in terms of its mismanagement of offshore facilities, facilities that I might stress were designed to be regional transit processing centres, but have instead become horrific places of indefinite detention. That is my definition of cruelty, when you indefinitely detain people in these centres. There's also been attempts to deprive asylum seekers of dignity and indeed intentionally delaying processing. The government has attempted, re-implemented Howard-era temporary protection visas, which only serve to keep people stuck in a permanent state of limbo. They've tried to stop asylum seekers from telling their stories, refused to answer questions and shut journalists out of detention centres. They've rejected New Zealand's compassionate offer to provide a home to 150 refugees, an offer which I note was first made by the Conservative New Zealand government. They've failed to respond to the Senate inquiry into the distressing reports of abuse, self-harm and neglect in both Nauru and Manus Island, and they've used every means at their disposal to dodge scrutiny and avoid accountability. They've completely abrogated their responsibility to find third-party resettlement options for the remaining asylum seekers, and they've engaged in a puerile campaign of dog whistling to whip up fear and anxiety in the community. While this bill pretends to have safety and security at its very heart, closer examination suggests it's little more than an unwarranted attempt by this government to further punish vulnerable people and choke their channels of communication. This legislation allows the minister to define specific items as prohibited in detention centres through a legislative instrument. It comes on the back of a failed attempt by the Turnbull government to ban mobile phones in detention centres last year, a bid which was overturned by the federal court which of course found that detention centre staff have no authority to confiscate mobile phones. The bill would also increase immigration officers' search and seizure powers within these facilities and allow both strip searches and the use of dogs for both detainees and visitors. It also indirectly empowers authorised officers to use force when conducting a search. While the prohibited items that this legislation will create aren't defined in the explanatory memorandum, that memorandum says those prohibited items might include things like mobile phones, SIM cards, computers, medications and healthcare supplements and offensive publications. The government argues that these things pose a larger risk to safety and security because of an increasing number of, and I quote, higher risk detainees. But they simply haven't made the case for this, especially since the new harsher regime will in fact apply to all detainees. Thus, it unfairly penalises the many asylum seekers who have committed no crimes whatsoever. Not only that, but because these ministerial decisions wouldn't be disallowable, the normal opportunity for this parliament to object to and overturn any inappropriate regulations won't be available. It's clear that the impact on detainees of having access to communication devices revoked would be severe on the detainees. In these detention centres, a mobile phone, it isn't just a means of communication, it's really a lifeline to the world beyond the detention centre, a lifeline to a world that is incredibly traumatic and destabilised so much of the time. Detainees rely on mobile phones to stay in touch with friends and families, and of course they need to maintain contact with their lawyers. Removing them would significantly add to the stress and mental and emotional harm they are already suffering in detention. Labor is also very concerned about prohibiting medications or health supplements. Here we want to see strong protections to ensure critical prescribed medications or supplements recommended by health practitioners are not included in lists of prohibited items. While Labor will always consider reasonable measures to improve safety and security, we believe those prohibitions are totally unwarranted. We also hold grave concerns about giving the minister broad unchecked powers to declare pretty much anything he chooses to be banned while removing this parliament's critical right of review. Why should we trust this government and this minister when they have demonstrated time and time again utter incompetence in the management of our detention centres and a callous disregard for the well-being and dignity of those people that are in them? This is a minister who has a record of campaigning relentlessly and, we can see, quite successfully, to expand his own powers. Of course, you know, he is quite content with having a running commentary continuously on judicial decisions and practices, despite most Conservatives would normally respect the separation of powers that exists between judiciary and this parliament, but not this minister, no. This is a minister that, of course, has built himself a mega department in which to exercise these new expanded powers. He's proven time and time again that he simply shouldn't be trusted with an expansion of unfettered power. At best, this bill is poorly drafted. It is rushed and there is a raft of unintended consequences. At worst, it's an active attempt to deprive vulnerable asylum seekers of their human rights while dodging parliamentary oversight. Labor referred this bill to the Senate for a thorough inquiry. There are around 82 submissions and more than 170 form letters received from around the country. They were nearly unanimous in having serious concerns about the fundamental aspects of this bill, and the vast majority recommended it not be passed. Submitters to the inquiry shared their profound unease about the broad powers this bill bestows on the minister. They were deeply concerned that the minister could decree absolutely any item to be prohibited, and that there would be no way for the parliament to object or overrule these decisions. Similar concerns were raised by the Parliamentary Scrutiny of Bills Committee, which is responsible for assessing proposed legislation against a set of standards regarding individual rights, liberties and obligations, the rule of law and indeed parliamentary scrutiny. In its Scrutiny Digest 12, the committee questioned, and I quote, "the appropriateness of allowing significant policy matters to be dealt with by delegated legislation." I must say I share these concerns. I'd also like to know why the minister isn't willing to be upfront about what it is he wants to prohibit. We've already heard reports of items like pens and paper already being banned in the detention centres. Who's to say that these things won't be added somehow to a list of prohibited items after this bill has passed the Parliament? I'm persuaded that the measures required by this bill are utterly disproportionate to the demonstrated risk. In its submission, Amnesty International noted that the High Court found mandatory detention of asylum seekers cannot be punitive. This bill, which imposes harsh restrictions on all detainees, demonstrably is punitive. It's important to remember that detention centres are not correctional facilities, and they should not be treated as such. As the Refugee Council of Australia points out, the bill applies, and I quote, "the same set of restrictive policies to all people in detention, irrespective of their past history, risk rating and vulnerabilities, to mitigate the risk presented by some." The Australian Human Rights Commission agreed that blanket decisions are inappropriate, saying restrictions should only be imposed in individual cases in response to individual risk assessments. The Scrutiny of Bills Committee also had something to say on this when it wrote, and I quote, "The proposed amendments in the bill would apply to all immigration detainees equally, despite the fact that around half the detention population is not made up of high-risk individuals." The committee's report then went on to find that the bill, and I quote, "unduly trespasses on personal rights and liberties." Notably absent in the inquiry were submissions supporting the government's position from the companies that actually run these detention facilities. In fact, neither Serco or IHMS chose to take the opportunity to make the case for why this increase in powers is necessary for good order within their facilities. It isn't just the Scrutiny of Bills Committee that has grave concerns about the impacts of the bill on the dignity and human rights of detainees. On this matter, Australian Lawyers for Human Rights wrote, and I quote, "By introducing dog searches, warrantless searches and possibly depriving interns of their mobile phones or medication, the bill allows the further traumatising and terrorising of innocent men, women and children. The behaviour which would be permitted under this legislation, apparently with no judicial oversight, is akin to the torture of innocent people." That is the Australian Lawyers for Human Rights assessment. The removal of mobile phones is also a particular concern to the Australian Human Rights Commission, which submitted that, and I quote, "prohibiting the possession of mobile phones engages and limits a range of human rights, including those relating to privacy, freedom of expression and association and protection of the family." The Parliamentary Joint Committee on Human Rights also saw the expanded search and seizure powers as being in conflict with the right of freedom from torture, cruel, inhumane, degrading treatment or punishment, and the right to humane treatment in detention. In summary, this bill is plagued with deeply worrying issues which must be rectified. Labor shares the concern raised by the Parliamentary Joint Committee on Human Rights, the Scrutiny of Bills Committee and the hundreds of people who took the time to write submissions into the Senate inquiry. I won't support a bill that offers unchecked ministerial powers and removes parliamentary oversight. This bill can't come at the expense of due process or the humane treatment of asylum seekers.
I thank the